Hello, friends. I welcome all of you on this ninth video of Law of Evidence. And today we will start with the second chapter of the Indian Evidence Act 1872. And in the current session, we will be discussing Section 5 of the Indian Evidence Act. Remember, friends, this chapter 2 is the most important chapter of the Indian Evidence Act. It provides the relevancy of facts, that is, it provides which facts are relevant. And Section 5 is the bulwark of the whole law of evidence as given in the Indian Evidence Act. Before proceeding further, we will have a quick overview of what all we are going to study in this session. First of all, we will go through the bare act provision of Section 5. Thereafter, we will see that what is the basic object, what is the basic principle of this Section 5 of Indian Evidence Act. Thereafter, we will discuss the difference between logical relevancy and legal relevancy. Further, the difference between relevancy and admissibility will also be discussed in this session. Friends, this is a very important question from the point of view of prelims, mains, as well as interview. So, the most important aspect of today's discussion will be this part where we will be differentiating between relevancy and admissibility. Thereafter, we will see certain important points which are asked in various examinations, and one of them is evidence obtained by undesirable methods. If an evidence is obtained by undesirable method, whether it is admissible or whether it is not admissible because of the means by which it is obtained. Thereafter, one important question we will see which has been asked in Haryana Judicial Services examination quite few years back, where they had asked whether the evidence that is provided by sniffer dog is it admissible. We will see the relevant case law in this aspect. And finally, we will go through the principles regarding admissibility of an evidence. Friends, this sixth part I have added, which is very important for those who are practicing in court, both for judges as well as for advocates. Before proceeding further to the chapter, I would just like to say that this is the most important section of the Indian Evidence Act, in the way that this is the very base, the very foundation on which the whole law of evidence as applicable in India is based. This section provides the very reason why we should have a law of evidence as enacted. Why cannot it be left to the logic? Why cannot it be left to the reasoning? Why cannot it be left to the common sense knowledge of the judge, of the advocates, and why all we require this Indian Evidence Act? Now, before proceeding further, we will just go through the bare act provision of Section 5 of Chapter 2. It reads, evidence may be given of facts in issues and relevant facts. This is the heading, and it states, evidence may be given in any suit, in a civil suit, or proceedings, in criminal proceedings, of the existence of or non-existence of every fact in issues and every fact in issue, and of such other facts as are hereinafter declared to be relevant, and of no others. Friends, this section very specifically says that evidence may be given of only two things: one, fact in issue, and second, relevant fact. But mind you, friends, it does not stops there. It does not stops at saying that evidence may be given of two things: one, fact in issue, and two, relevant fact. It further goes on to clarify of no others. That is, that it further says that evidence of things other than this cannot be given. Now, an explanation is added to it which says this section shall not enable any person to give evidence of a fact which he is disentitled to prove by any provision of the law for the time being in force relating to civil procedure. So, if there is any provision which provides or which disentitle a person to give any evidence regarding a thing which is prohibited by the civil procedure code, then he will not be able to give that evidence. Now, two illustrations are added to it. One is from criminal and another is from civil proceedings. It says that A is tried for the murder of B. So A is tried, suppose he is A, and he is tried for the murder of this person B who has been murdered. A is tried for murder of B by beating him with a club. So he has beaten him with a club with the intention of causing his death. An intention in the mind of A is to cause the death of B. At A's trial, the following facts are in issue. A's beating with club, that is A beat B with club. A is causing B's death by such beating, that A beat B with club, and as a result of this beating B died. Then third, A's intention to cause B's death, that A had in the mind intention to kill B. So all these are facts in issues which are there at this trial. So evidence can be given of all these three things, that is A beat B with club, second that B died because of this beating which may be proved by post-mortem, third that A had the intention of beating B which can be proved by the circumstantial evidences. Now in civil suit also an illustration has been given. Friends, mind you that many a times the questions are framed based on these illustrations. So please go through these illustrations very carefully. A suitor does not bring with him, that is, a party does not bring with him and have in readiness for production at the first hearing of the case a bond on which he realizes. So if there are two parties, party A and party B, now party A relies on a particular bond and he does not bring it in the court in the first hearing and he does not have it in readiness. This section does not enable him to produce the bond or prove its contents at a subsequent stage of proceeding. So if in the first hearing on which he realizes, if he is not able to produce it, if he has not brought it, though he is having it, then he cannot produce it at the subsequent stage of proceedings. Otherwise, then, provided he can do if it is provided by certain conditions in the civil procedure code. So finally, to brief up, Section 5 simply says that evidence can be given of every fact in issues and of relevant fact, but of no other. Now, we will just analyze the various aspects of this section. What is the object? What is the principle? Why to mention this section in the Indian Evidence Act at the very beginning of the chapter 2? The reason is that this is based on one of the first cardinal principle of law of evidence, that evidence must be confined to the matter in issue. That is, evidence should be limited. It cannot go unlimited. If it is unlimited, if it is not limited by these uh, cardinal principles, then no trial can actually end. There will be limitless evidences, limitless things which can be brought by the parties. So, in order to limit it, in order to restrict the trial in the court, it is said that evidence can be given only of fact in issue or relevant fact and of no other. So if they ask you the object or the principle, that is, it restricts the trial in court to the fact in issue and is based on the first cardinal principle of law of evidence, that evidence must be confined to the matter in issue. Now, we will discuss some important things regarding section 5. As I told you that this is the most important aspect of the Indian Evidence Act. This is the very base, the very foundation of actually why we required the law of evidence. That is to say, it is the philosophy of law of evidence. Now, what would be the difference between logical relevancy, legal relevancy, and admissibility? Let us see. Friends, logical relevancy means those things which are based on reasoning. And this reasoning can be of two types, inductive or deductive. And it is purely a academic exercise. So, one of the logical reasoning would be that if there is broad daylight, then certainly one can say that the visibility will be good. This is one of the logical reasoning which is done, which can be inductive or which can be deductive. And it is totally an academic exercise. For example, Kafka's work on the trial, Hall of Justice, where they have discussed that what should or what could be the logical relevancy in the various things. Mind you, this is a very good book and one should read it, where they have provided that how a person or how a common person is devoid of the judicial services, how he is devoid of legal help by those who are surrounding the hall of justice. So, logical relevancy consists of reasoning, while legal relevancy goes one step further, and it consists not only reasoning but those reasoning which are legally recognized. Now, what are those reasoning which are legally recognized? Those which are mentioned under section 6 to section 55 of Indian Evidence Act. So now you may ask that, can you give one example as to things which are logically relevant, that is, it is based on reasoning, but legally irrelevant, that is, there is no legal relevancy of it? Yes, friends, there is, and there is a very good reasons for it. For example, the character of an accused. Now, by any logical reasoning, it can be said that character of an accused is logically relevant, but it is not legally relevant. And why it is not legally relevant? Because if the character of accused is allowed in the court, it may create a prejudice in the mind of the judge, and that will lead to denial of right of fair trial to the accused. So a thing which is logically relevant is not legally relevant because of certain principles on which the law court are to function. And a famous quote I will like to give from Professor Thayer, where he says that courts are not engaged in academic exercise. There is a difference. What he says is that there is a difference between academic exercise and there is a difference in awarding justice. And what is the difference? The difference is that they are limited. Awarding justice, requirement of court is awarding justice, and they are limited. They are limited by what? They are limited by public policy. They are limited by expediency. They are limited by convenience. So, what he says is that courts are not engaged in academic exercise with them. The search for truth is not the main matter. Their desire to know this and their ability to use it are limited by their requirements of awarding justice. So, there is a difference between the academic exercise and there is a difference between the awarding justice or what the court does. And what is the difference? The difference is that awarding justice is limited by various policies, by various requirements of the society. Now, this is what is the very base of the very philosophy why we actually require a law of evidence. Why cannot we leave it to the basic reasoning, basic violation, basic cognitive sense of the judges? So, the real origin of rules of evidence lies in circumstances that distinguishes scientific investigation from judicial inquiries. Now, let us proceed further. We have seen that logical relevancy is one which is based on reasoning, and that is a purely academic exercise, while legal relevancy is one which is based on reasoning plus allowing only those reasoning which are legally recognized. Now, what is admissibility? Admissibility is one step further. It is reasoning which are legally recognized plus which are approved by public policy. So it consists of reasoning, but only those reasoning which are legally recognized and that too which are approved by public policy. We will see certain examples of how things which are legally recognized, things which comes within the logical reasoning but do not fall under public policy. Now, so we can say that if logical reasoning is a broader set, then legal relevancy is a subset of it. And admissibility is a further subset of it. Now, seeing this, let us proceed further and see the difference between relevancy and admissibility. And as I told you at the very beginning of this session, that this is the most important aspect of the whole discussion which we will be doing, as it has been asked in the preliminary examination, in the mains examination, and in the interview examination time and again. Here we will use a famous case law of Ram Bihari Yadav versus State of Bihar. In this case, the Supreme Court said that these two terms, that is relevancy and admissibility, are not synonymous. They do not mean the same thing. And what they said, facts which are relevant may not be admissible. So there are certain facts which are relevant as given under section 6 to 55 of Indian Evidence Act. But there are certain things which, though they are relevant, may not be admissible. But they are not admissible. And why they are not admissible? Because admissibility requires one more thing, that is approval of public policy. As they do not have approval of public policy, so though they are reasoned, though they are legally recognized, and thus they are relevant, yet they are not admissible. And there are two examples which I have brought before you. One is, you can see these two husband and wife, and they are arguing among themselves. So communication between husband and wife during marriage, they come within privileged communication. They may be very much relevant, yet they are not admissible because of public policy. Then communication between advocate and client, they are relevant, yet they are not admissible because they also come within the purview of privileged communication. Then the second point which was said by the court in this case of Ram Bihari Yadav versus State of Bihar is that there are facts which, though admissible, are not relevant. So suppose this is relevant facts, this is admissible facts. So there are certain relevant facts which are not admissible. Similarly, there are certain admissible facts which are not relevant. And one example of it is questions asked from a witness in cross-examination as to his character to find out his credibility. So if there is a person and that person is brought before the court and the other party thinks that his character is such that he always speaks lie, then questions may be asked in cross examination as to establish that he is a liar, that he has already been convicted for perjury. So those things, though they are not relevant to the case under issue, though they are not relevant to the matter in issue, fact in issue, yet they are admissible because they have got a bearing on whatever the witness is going to say. So in this case of Ram Bihari Yadav versus State of Bihar, the Supreme Court said that first, these two terms, that is relevancy and admissibility, are not synonymous. Second, there are certain facts which are relevant, yet they are not admissible. For example, privileged communication. At the same time, third is that there are certain admissible facts which are not relevant. For example, questions which are asked in order to establish the credibility of the witness in cross examination. Now, so I hope you understood the difference between the two terms. Now we will again go to another question which are asked time and again, is whether evidence obtained by undesirable methods admissible? Now the answer to this question is that they are. Yes. The court is not concerned with the method by which the evidence has been brought. The court is concerned with the evidence, no matter how it has been brought before it. So, in the famous case of Magraj Patodia versus R.K. Birla, it was said the test to be applied in considering whether evidence is admissible is whether it is relevant to the matter in issue. If it is admissible. and the court is not concerned with how it was obtained. So the court is not concerned with the way the evidence has been brought. What the court is concerned of is that first, whether it is relevant, and second, whether it is admissible or not. So the relevant admission remains relevant even if it was obtained by improper or unlawful means. A famous case in this is the case of R versus Christoph. Now, as you can see, I have put the photo of a jewelry shop. What happened in this case is that the police, they themselves set up in disguise a jewelry shop, and they pretended that they are interested in buying stolen property, and they had put CCTV camera so that all the things are being recorded, all the transactions are being recorded, and by this way they were able to catch the thief who were doing this dealing in the stolen property. Now when it was said that can this evidence which has been obtained by such type of activity is admissible, the court found that it is admissible and it will be admissible. So the process or the way, the how an evidence has been obtained is not material. What is material is that whether it is relevant and whether it is admissible. Now another question, as I asked you few years back, it was asked in Haryana Judicial Services examination that what is the admissibility of evidence that has been collected by sniffer dog. For example, you must have had seen that sometimes police or investigative agencies use a sniffer dog, and those sniffer dogs are able to recognize either the theft or the stolen property or the drugs. Now, in Dinesh Thakur versus State of Assam, it was held that this evidence cannot be taken by the court. It cannot be taken as evidence for the purpose of establishing the guilt of an accused. The faculties of sniffer dog can certainly be used for investigative purposes, but they will not be taken as evidence for establishing the guilt of an accused. Remember friends, the case law is Dinesh Thakur versus State of Assam. Now, as I told you in the last, we will be discussing one important aspect, and this is more relevant with respect to the court proceedings, with respect to the pleading, with respect to the judges as well as advocates. That first thing is that who decides whether a particular evidence is admissible or not? Then section 136 of Indian Evidence Act clearly states it is for the court, it is for the judge, it is for the presiding officer to decide the question of admissibility of evidence. That whether a particular evidence is admissible or not, section 136 clearly says that it is the court which will decide it. But when should it decide it? Should it decide it at the time of judgment, or should it decide it as soon as it is given? Then it is clarified that it should be decided as it arises. It should not be reserved until judgment of the case is given. So the moment a witness commences giving evidence which is inadmissible, he should be stopped by the court. So, though it is for the court to decide whether a particular piece of evidence is admissible or not, and section 136 clearly states it, the stage at which court is to exercise this power is not at the stage of judgment, but at the stage where it is being given. So as soon as a witness is giving an evidence which the court thinks is inadmissible, he should be stopped at that very moment by the court. by the presiding officer. Then, a party objecting to the question must do so as soon as it is stated and before the answer is given. Now, suppose party A is giving an evidence and party B feels that this evidence is inadmissible, then should party B wait till A gives its evidence and the trial comes for final argument? No. As soon as A is giving the evidence or is about to give the evidence and B feels that this is inadmissible, at the very moment it should object to it. It should not wait for a later moment. When an irrelevant document which is not relevant as per section 6 to section 55 of Indian Evidence Act is tendered, an objection should be made at the very time. If it is not taken in time, it is considered waived. So, suppose there is party A and party B. Party A is giving a document which party B thinks is irrelevant. Then at that very moment only party B should state its objection. And if it does not state, if party B fails to do so, if party B does not object, then at a later stage party B will not be allowed to object it. And it will be considered that party B has waived and has given consent to it. So this is what we were to do in the present section 5 of Indian Evidence Act. Just a quick recap of what all we have done in this session. We started with bare act provision of section 5, which simply says that evidence can be given of fact in issues and relevant fact and of no others. Then the principle or the object behind it is to restrict the trial of the court to the fact in issue, and it is based on the first cardinal principle of law of evidence, that evidence must be confined to the matter in issue. Then we saw the difference between logical relevancy, legal relevancy, and admissibility. Logical relevancy is based on reasoning. Legal relevancy is based on reasoning and legally, those reasoning which are legally recognized, and admissibility is based on reasoning, legally recognized as well as approved by public policy. Then we saw that the difference between relevancy and admissibility, as has been held in the famous case of Ram Bihari Yadav versus the state of Bihar, is that first, they are not synonymous. Second, there are facts which are relevant but not admissible. At the same time, there are facts which are admissible but not relevant. So they are not synonymous in nature. Then we saw that by whatever means evidence is obtained, if it is relevant, it is admissible by the court. The method by which it is obtained is not a matter of concern for the court. And we saw the famous case of R versus Christoy. And we also said that the relevant evidence remains relevant even if it is obtained by improper or unlawful means. Then we saw that admissibility of evidence of sniffer dog in Dinesh Thakur versus State of Assam. It was said that it can be used for investigation purposes, but its faculties cannot be taken as evidence for purpose of establishing the guilt of an accused. Then we saw the principle regarding admissibility of an evidence, that it is for the court to decide whether a particular evidence is admissible or not, and it should not be reserved until judgment is given. Rather, it should be done at the very time when evidence is being given. Then the party who objects to a question should do so as soon as it is stated or before the answer is given. And similarly, when a party is giving a document which is irrelevant and the other party has got some objections to it, it should be, those objections should be raised at that very moment. And if those objections are not raised at that very moment, it is considered to be waived. Thank you, friends.